Thank you all for joining us today for another episode of our podcast, Moving to Value Unscripted. My name is Dr. John Rodas, and I am a recovering ex-hospital president, and I'm proud to be the president of the Moving to Value Alliance. The Moving to Value Alliance, MTVA, is a 501c3 organization. It is a multi-stakeholder grassroots community whose purpose, put simply, is to foster a community that aims to create a value-based healthcare ecosystem with high-quality outcomes at a reasonable cost for plan sponsors and their members, beneficiaries, or employees. Our community has grown substantially over the past few years. We started in Connecticut, but now have nearly 1,000 members from more than 40 states all over the U.S., and our members include many value-based influencers. I want to thank our sponsors whose support makes this presentation possible. We'd like to give special thanks today to our trade member sponsor, Southern New England Healthcare Organization. We are joined today by my fellow board members, Lisa Tremble and Dr. Steve Schutzer. Lisa Trumbull is the CEO of SOAN Health, Southern New England Healthcare Organization, a physician-led clinically integrated delivery system in Connecticut and Massachusetts. Dr. Steve Schutzer, a nationally renowned arthroplasty surgeon, is one of the founders of MTVA and is the co-founder and president of Upswing Health. Our special guests today are Sarah Rai and Alden Bianchi. Sarah is partner and Alden is counsel in McDermott, Will & Emery's Employee Benefits and Executive Compensation Group, who focus on health and welfare plan issues. As experienced attorneys, they advise clients on health and welfare plan fiduciary issues. For those of you who don't know, McDermott, Will & Emery is one of the largest and most prestigious law firms in the world, with offices throughout the United States, Europe, and Asia. Welcome to Moving to Value Unscripted, Sarah and Alden. It's great to see you both.
Thank you. Great to be here.
Thanks for having us.
So let me maybe kick it off if I can today. And maybe, Alden, I'll ask you to start. And just for our listeners, maybe to just give us a little background on ERISA law and some of the modifications over the years. And then we'll ask Sarah to kind of bring us up to current times and how the Consolidation Appropriation Act, enacted in 21, I guess, signed in 20, how it affects ERISA law.
Sure, John, and thanks. We could spend the entire hour and then some on the backstory of ERISA. So what I propose to do instead is just to do three high-level bullet points about history, ERISA's development and its enactment that I think are enlightening and might frame today's conversation. The first was, and folks might not realize this, ERISA's history actually goes back to 1962. It was enacted in 74. But it was President Kennedy who commissioned a study on retirement income generally. That started during his tenure, and it didn't develop fully until 74. Secondly, and this is critically important for many of the topics being discussed today, and that is the strong ERISA preemption provision happened at the very last minute. Neither the House bill nor the Senate bill had anything like what we have today. The strong ERISA relates to preemption rule. And that was a product of the conference committee. And to this day, no one quite knows what happened during those few days. But there was enormous pressure put on the committee, both by big labor and big management, which today would be unfathomable to have that sort of cooperation. The third point, and this will lead into Sarah's comments, is that welfare benefits, as folks might recall, were really a backwater. This was a pension bill principally, until someone realized that Jimmy Hoffa could steal from a funded welfare plan as fast as he could steal from a funded pension plan. And it was that reason and that reason alone that welfare benefits were even included in ERISA, indeed as an afterthought with far fewer protections. And indeed, if you go back to the time immediately following ERISA, so Sarah and I and one or two other folks in our department really do focus principally on welfare benefits. That would have been unheard of in big law or any other firm in 1976, 78, and around there. That is a relatively recent development. So sorry, take it from there, but I think that gets us here.
I learned a lot from that. All 1962.
Right.
Who knew?
Yeah, and now we are, celebrating this big 50th anniversary of ERISA. But yes, I think we have the foundation of ERISA, obviously always applied to health plans, and now practically we're seeing more and more focus on health plans as far as actually complying with ERISA and just some of the principles of disclosure. So the Consolidated Appropriations Act that was signed into law on December 27th, 2020, and was really the most significant health plan legislation that really had been passed since the Affordable Care Act, probably the single largest piece of healthcare legislation that really impacted many different aspects of health plans. So one aspect of the CAA was obviously some COVID relief. We had a lot of legislation that was passed in 2020 and around that time related to pandemic relief, just giving more flexibilities to health plans to be able to cover more people and just kind of let people be able to change their elections a little bit more. But really the lasting impact of the CAA, once that relief has now expired, has been additional reporting requirements for pharmacy benefits for just any service providers that are providing services to any health plan, and just generally some of the provisions that have stuck with us today. So things like surprise medical billing really originated from the CAA, mental health and substance use disorder benefits really started to shift with the CAA, in addition to, of course, the Mental Health Parity and Addiction Equity Act. But the CAA was really the single largest piece of legislation that's come out in the last few years that's really put the focus back on health plans, or really for the first time on health plans, since, as Alden was saying, the focus has really been in the ERISA world and in the benefits attorney world, mostly on the retirement side, simply because we saw enforcement on that side more and more. And now the Department of Labor has come out since the CAA has been passed and really expressed a large priority, which is looking at health plans from the angle of, are you requesting compensation information from your service providers? Are you going out and getting that information? Are you analyzing it and really making sure that you're processing it and making the best decision for the health plan to be able to use its assets in the best way, essentially? And that's really where the case that we talked about, the Lewandowski case, has come from.
And just to be clear, Sarah, we're talking about the laws apply to both insured and self-funded plans, right? They're not. A lot of people think, oh, it only applies to self-funded plans, but that's not true. Is that fair?
Right. ERISA, the Consolidated Appropriations Act, all of these both apply to fully insured and self-funded plans. Now, to the extent there are state laws that impact health plans, generally those are going to be preempted for the most part by ERISA for a self-funded plan, but certainly these larger disclosure requirements are still applicable both to fully insured plans and self-funded plans.
John, your question raises a common misunderstanding out in the community. Sometimes folks tend to refer to self-funded plans as ERISA plans and as distinguishing them from fully insured plans. And that's not the case. ERISA applies with equal force to both. But obviously, in the case of self-funded plans, the state insurance mandates and other requirements apply.
While we're talking about the basics going back 50 years, 60 years, tell me, it took 30 years to close some loopholes in the pension side with the Pension Protection Act. I think it was 2006, and then 50 or 48 years to close it. What I mean, ERISA had good intent, but obviously had no enforceability or teeth. What was missing back then when they came up with this?
I'll take first stab at that. I'm not sure it's true that ERISA didn't have any teeth. It doesn't. It has a fairly robust civil enforcement scheme in it, but it's very narrow, and its jurisprudence is developed in very odd ways. But I think something far more nefarious is happening these days, particularly with the CAA, and that is the rules I think are clear enough in the CAA, for example, that one must make substantial, robust disclosures of compensation. It's not happening. And when I say it's just not happening, the vendors out there are just, I don't even know what to tell you. It's almost like the rules don't exist. So what now has to happen, and I'm going to use a generic term that I don't often use, the government, whether that comes from the level of the Department of Labor, the IRS, or it comes from the administration or somewhere, or even Congress, someone's got to step in, because particularly the broker disclosures are being ignored virtually wholesale. The disclosure requirements tend toward obfuscation. Of course, on the hospital side, they just ignore them. They don't do it. I don't know what to tell you about that one. I'm baffled. I've never seen such wholesale noncompliance that seems to be just tolerated indefinitely. Something's got to move there.
Yeah. Yeah. It's interesting. Maybe not the government, but the plaintiff bar will be stepping up. And I mean, that's what I would think. I wouldn't count on the government saving
Well,
us.
I had the same thought. It's like we've set a speed limit. We have speed limit signs up everywhere, and everybody's still driving 90 miles an hour, and everyone's ignoring it. So I've been struck, Alden, by the total, and I can't figure it out. Is it that they're ignorant of the law? Is their counsel, their audit committees, their finance committee, are they totally ignoring it, or they're not aware of it? I'm not really sure. It's a hypothetical question, but I can tell you, we've all seen full page ads taken out by attorneys saying, "Hey, if your employer is not doing good by your health plan, you should sue them." So I think if it's not the government, Alden, to your point and to Steve's point, it's going to be litigation, which is an ugly way to kind of achieve, with all due respect to attorneys, it's not really the most efficient way to achieve progress in the area. Lisa?
No, I'm just shaking my head, having gone through this as an employer. I agree with Alden. The disclosures just aren't happening, no matter how many times you ask for them as an employer. And it's gonna take moving the business to brokers that are a little more straightforward and interested in doing the right thing for the employer. But even given all that, the onus is on the employer to make sure they're doing everything they can to comply. And I'm wondering, Alden and Sarah, if you could just outline a few of the key fiduciary responsibilities that employers have. And because we're talking a little bit about brokers and middlemen, are there any key fiduciary duties or responsibilities for those individuals, as part of the Consolidated Appropriations Act?
Yeah, and if I could pick up on that question, Lisa, just a little bit. I just yesterday was reading something. I was kind of stunned by it. It was by a law firm, and it said the health insurance company takes on responsibility for compliance. And I said to myself, I don't think so. So in answering Lisa's question, could you guys just clarify this fiduciary thing, what a fiduciary means, and who is really the fiduciary and who's responsible?
Well, and the responsibilities segmented by the employer, the broker, or the insurer.
Yeah, I think, right, what's coming at the heart of these disclosures from brokers, from any service provider, this is all trying to provide information so that the employer, the ERISA plan fiduciary, can actually make decisions and carry out its duty to monitor under ERISA, right? So I think historically we talked about how there wasn't as much compliance on the health plan side. A lot of that was because there wasn't this price information transparency. So all of these attempts to, hey, now you have to go get broker disclosures. Now you have to get this information from pharmacy benefit managers. This is all trying to get at that essentially almost excuse that employers previously had that, yeah, we'd love to, carry out this duty to monitor that we've always had under ERISA fiduciary duty. We just didn't have the appropriate information to be able to do that. And because healthcare information has sort of been so opaque historically, that it's been hard to figure out where exactly the money is flowing to, what broker is getting what type of referral fee for our business and what other vendors are benefiting from us, that the CAA attempted at least to come in and say, okay, now legally you are required to receive these very detailed fee disclosures from all of your, essentially any brokers or consultants who are providing services to the health plan. And I think a lot of I don't want to say necessarily dodging, but frankly, I think some brokers and vendors are essentially trying to dodge this requirement. A lot of it comes from the fact that the DOL, the Department of Labor, did not give us new regulations on the health plan side. They essentially said, you know what, we have fee disclosure regulations on the retirement side for the time being. Use those in a good faith manner, whatever that means, and try to interpret them on the health and welfare side and kind of figure out if you are not a broker or a consultant. These are undefined terms technically under the regulations. It's a very broad term. So certainly for employers, it would be the less risky way to just go ahead and request these fee disclosures from all of your vendors, whether they're technically called brokers or consultants or not. And certainly that's what we've been encouraging our clients to do. But to your point, Lisa, it's certainly not easy to just get these disclosures, unfortunately, even when you ask, please provide them, or if you're not providing them, why are you not providing them? It's oftentimes the case that vendors are trying to avoid getting pulled into these disclosures, and for the time being, without clear definitions, it seems like they're able to, if and when we get actual Department of Labor enforcement or regulations on this side. Of course, at that point, that might kind of be the final, shoe to drop to kind of really force folks into compliance. But for the time being, we haven't really seen that. But certainly still the obligation of the employer plan sponsor as the ultimate fiduciary under ERISA to keep asking for that, and keep at least trying to get answers on why they're not getting disclosures if that's the case.
And Sarah, just to follow up on that, what type of documentation should an employer have to demonstrate that they've done that? If you've got the disclosure form and the broker refuses to fill out the disclosure form.
Yeah, I think if they are refusing, I think it's, wanting to get in writing clarification of, what is it that you think doesn't require you to make this disclosure? Do you think you're not a covered service provider under ERISA, essentially, which is, again, very broad terms, seems like a little bit of a maybe shaky position, but frankly, until we get that response or get those better definitions from the Department of Labor, it seems like it'll kind of be a bit of a gray area for the time being. But certainly, I think to protect the plan sponsor, the employer, it's still a good idea to ask for that.
There's also a nuance in Lisa's question that I'd like to circle back to, and this also goes back to John's introduction to the issue. And that is, ERISA starts with the presumption that there is a default fiduciary. That is, if you don't say anything, who's the fiduciary? Well, it's the quote unquote employer. Well, who is the employer exactly? Well, if you're a corporation, that's your board of directors. If you're an LLC, it's your managers or whoever they are in your documents. If it's a partnership, it's the partners, the real partners, not owner partners. And here's the mistake a lot of employers make. Well, oftentimes in a contract, this isn't a mistake. In a contract, they'll name the carrier as the claims fiduciary, limited purpose, just for purposes of adjudicating claims. They might do the same with a PBM. But also employers will have fiduciary benefit committees. But that committee is nothing until the board of directors designates it as the fiduciary. And if you can go into any number of companies, oh, we have a fiduciary committee and they do they are our fiduciary. Well, where's your delegation from your board or governing authority? If you don't have that, it didn't happen. And here's a practical reason why that delegation is so important. In the event of a lawsuit against you, and we know those are coming, if there is no proper delegation, all of the members of the board of directors are open to discovery on all issues. They are the fiduciaries. But if you have properly delegated authority, the only thing you can inquire of the board is, did you properly oversee the delegation? Those are two vastly different things and can have real world consequences.
That's a huge distinction. That's a huge distinction. So at the end of the day, if I could make sure I understand what you've just said, if the board, if there's no formal documentation anywhere, this says the board has delegated this authority to these folks, they're the ones ultimately then responsible, saying, hey, you guys are breaching your fiduciary responsibility as a board. You haven't delegated it. We've all been on boards. And, we've seen audit committees. I've been on numerous finance committees, audit committees. We analyze the retirement 401k or 403b plan and make sure we're optimizing it. And we've done all this for so long, or the corporations have done that for so long. In this space, though, what's the minimum they have to do to at least show that they're compliant with the law? Because I think when you think about ERISA, it's a kind of almost minimum standards, right? It's not really, this is the best you should do, it's the minimum. What's the minimum they really should do? Just take us through a company who ignored this up until now. What do they need to do?
John, you pointed to it. Think of a finance committee. If you look at the company's the hospital's bylaws or somewhere, there has been a formal delegation, a creation of that committee. It's either in the act, the articles or bylaws or whatever, or there's been a vote, a formal vote establishing that committee. It's simply a vote voted to establish the so-and-so company welfare benefits committee, voted to, they might adopt a charter, they might designate people, it might be designated by, consist of the, whoever, the board co-chair or something like that, designating who's on it. But yeah, it's a simple straightaway delegation of authority. And then it would say voted to establish the committee and to designate them as the ERISA fiduciary under site section of ERISA. And that's how our votes look. They're very simple.
And then that committee is going to work with the CFO and the CHRO to start saying, hey, make sure we have compliance. Have we asked our brokers for the disclosure for their fees? And have we looked at our plans to make sure we don't have gag clauses? And is that, maybe Sarah, take us to the next step. So what does that company do once they've now made that delegation? Take us down that rabbit hole.
Yeah, exactly. I think it's not enough just to kind of like have a standing meeting on the calendar every once in a while. The committee should really be looking at, yes, whether they've requested these fee disclosures that are now required by the CAA of all of their, potential brokers, consultants, essentially all health plan vendors. And again, if they're not providing them, why are they not providing them? Looking at whether the plan has any gag clauses in place in its agreements with any vendors, and whether it's gotten information to timely file the attestation, saying that it does not have any impermissible gag clauses, making sure that all of the CAA reporting is being done on a timely basis. So, and practically, I think to your point, John, right, it's working with the HR team on a lot of this, because they're usually the ones who have historically been in contact with your third-party administrator, your insurer, if you have a fully insured plan. So it's also coordinating with them. It's not like all of this is now suddenly on just the fiduciary committee. It's really working with those people who are familiar with the plan and work with it in their day-to-day job, but really performing that oversight function. And frankly, I think sometimes we give fiduciary training to these fiduciary boards, right, or committees, and realize that perhaps they didn't understand the full scope of the responsibility or exactly what they should be doing, which is why it's important to, hopefully have some experienced and competent counsel that's guiding you through, what does this mean? Because to Alden's earlier point, when you are an ERISA fiduciary, technically that means you are exposed to potential liability, even as an individual who sits on that fiduciary committee. So, when we had really controversial things happening like reproductive health care, figuring that out after the Dobbs opinion, we had this sort of horror story that many employers were thinking through of, what if my fiduciary committee got sued and potentially had criminal liability simply because we're providing reproductive health care benefits now after the Dobbs decision. And although that sounds, a little outlandish and crazy to think like that it could happen simply because you sit on a fiduciary committee of a health plan, technically it was possible. Luckily, we didn't see it actually happening. We didn't see any, perp walks being done by fiduciary committees, but technically it was possible. It was unfortunately one of the sort of worst case scenarios that we walked our clients through at that time, and certainly has continued to be a worry as more states have made laws that restrict reproductive health care benefits. But in general, right, I mean, it's not just, oh, I'm on a committee, sometimes we meet, sometimes I look at stuff right before the meeting, or not even kind of just rifle through the papers during the meeting. That's probably not going to be enough to be carrying out your fiduciary duty, that is ultimately not to know everything about the plan, but really just that duty to monitor, to ask questions of the advisors, whether that's a broker or attorneys, or advising even from the HR team on what you've done historically, but just at least ask questions, really gather that information, and based on that information, kind of on a reasonable person standard, assess that information, and try to make the best decisions for the plan and carrying out its benefits for folks.
Folks, I have a question submitted by a friend of this group, Jeff Hogan, former board member. He loves the CAA. So he submitted a question that I'll read here. Most employers have relied on someone else to perform their health plan fiduciary duties in the past. In fact, most named fiduciaries have conveyed plan duties, including procurement, to ill-equipped HR personnel. What's a good starting point now for employers for them to understand their fiduciary duties and the needed resources to appropriately manage assessment of plan vendors, procurement, contracting, and accountability?
I would also add just one layer deeper than that. I mean, obviously, the law is a big omnibus appropriations act, right? But there was a few hundred pages devoted to this subject. And I was struck by how granular the detail is about what you're really supposed to do vis-a-vis like drugs, for example, your top 50 spend. So maybe let's try to address that question and then, get down again, a layer down.
Some of it is that employers are delegating this. The point I think Jeff is making in this question is that they're delegating this to folks within their organization who really are not equipped
Right.
to really respond to
That's
that.
a good point. That's a good
Yeah,
point.
I think and I think it's a little bit more than that, Steve, because the employers and staff that they may have may not be equipped to procure healthcare services, but most of them don't understand how healthcare is delivered, right? And they don't understand where the pitfalls are in, the costs and the benefit structure and the places where all the middlemen can take fees. And we talk about, us just being in the industry find it perplexing and confusing. So if you take an employer that has nothing to do with healthcare, that has an HR department and a CFO that has nothing to do with healthcare, and now you throw all these responsibilities at them, now they've got to understand everything about healthcare in order to do their fiduciary responsibility. So getting to Jeff's question and then what John said, how does an employer figure out what is the right structure for me? How do I educate those that are going to be responsible on my team to be able to do this? And how do we support them so that the organization is not exposed to liability?
I think it is the real world, guys. HR folks, they get fired for changing the plan. We've all been beaten with HIPAA privacy laws, and I wonder sometimes if HIPAA hurts in this regard, because I've heard 1,000 times we can't get between our employees and their doctors. We can't get into the details.
Yeah, I think, Steve, this might surprise you where I'm starting with the response. And I'd say it starts with a fundamental shift in mindset. And here's what I have in mind. If you ask a rank and file employee, what's your health plan? I got Blue Cross Blue Shield. No, you don't. Blue Cross Blue Shield is a vendor to your health plan. For too long, and this happened for decades with 401k plans, but it's changed with 401k plans now, but not yet with health plans. In 401k plans, you think I go get a 401k plan from pick your platform vendor, Fidelity, Schwab, whoever, but you don't. They are service providers to the plan. It is the employer's plan. The employer is the plan sponsor, the employer. And when you have that fundamental shift from we're going and buying a plan to it is our plan that we need serviced, now all of a sudden at the very highest levels of management, the group health plan takes on a fundamentally different and more important role. So that's number one. Secondly, and again, following the lead of the 401k plans, fiduciary governance has become a real thing. In most companies, you look around at their 401k plan, they have a formal benefits committee. It's advised by consultants. There's a formal schedule. Folks have developed the expertise to run a 401k plan. A similar skill set really has to occur on the health plan side. And any employer that doesn't is going to be on the wrong end of the V in a lawsuit eventually, an employer of any size. Now you get down to the third level, and that is your consultants. And I had a broker make a stunning claim a few weeks ago. He said to me, the companies that are paying the most unnecessarily are the very largest companies because they're just doing whatever their consultants are telling them to do. They're not pushing back. They're not thinking about it. Oh, well, pick your big name consultant. They're global. They know everything. They said to do this. It must be what we need to do. No, you really need on that fiduciary committee, you need people with some depth, and they don't have to be necessarily physicians. It'd be great to have one or two, but someone has to push back. And then the last thing I'd say, and this is so fundamental, and I'm shocked that it's gone this far, Congress, the courts, and the regulatory agencies have got to make abundantly clear that claims data is the property of the employer. It is not the property of anyone else. Full stop, period, paragraph. Do not pass go. You get the idea. I'm on a rant, so sorry.
So true. So true. But this group has talked before that the employer now carries a heavy burden. I mean, I don't envy them. I mean, they want to make their widgets and do what they're doing. I think this is more than they ever bargained for. And the language of the CAA, and again, I'm far from an attorney, but John and Lisa would agree, the language is remarkably explicit. I mean, I look for gray stuff, but this is pretty clear. I mean, they have to show an unbiased, reproducible method for procuring healthcare services for their employees, not for someone else's employees. They have to know the demographics, they have to know their background. What advice would you give an employer to reach that fiduciary standard? How do they understand what's in the best interest of their beneficiaries?
Yeah, I think to our point earlier, right, that if you're an employer and not in the healthcare field, right, and kind of making widgets or providing other services, I do think one of the probably easiest ways to get at understanding all of these obligations is to partner with a broker, consultant, attorney, all of these types of advisors. But I think to Alden's point, certainly don't follow what they say blindly, right? Kind of take everything with a grain of salt, ask the questions, because again, that's part of what ERISA contemplates as carrying out an employer's fiduciary duty, is not only to get advice from appropriate advisors, but to clarify, to ask questions when needed, to really understand that advice, and not just sort of checkmark whatever they're saying and just say, yep, they're the experts. I'm sure that's right. I'm sure they're charging us for what they should be charging us. I think it's being kind of that conscientious consumer almost of, yes, you're getting these services, but do they make sense at a basic level? If you don't understand them, have them explained to you. I think going through that process and kind of doing your due diligence to the extent you can, of course, knowing that when you are an employer who doesn't have experience with healthcare, of course, you have a little bit of a disadvantage, but certainly the reason that you're paying these folks, that you're hiring advisors, brokers, consultants, is to help you understand. So I think to the extent you don't understand, making sure you're asking questions. Again, I think it's almost like being a good consumer of anything. I think, just wanting to make sure you're understanding and not just blindly following the advice, because I think that's where we've even seen lawsuits come out, right? Where the allegation is, well, you just let your insert service provider, your third party administrator, your pharmacy benefit manager, some other type of third party make these decisions and kind of run amok, and you weren't appropriately monitoring them, you weren't asking questions, you didn't think, oh, that seems like an oddly huge fee that they're charging me for this service, perhaps maybe I should, benchmark or compare or go out and request other quotes from other parties, for instance. Oftentimes those are the allegations that we're starting to see now, that has really put the focus more on fiduciary practices, whether companies have a committee that's reviewing all of this, that's requesting fee disclosures, that's requesting, whether there are impermissible gag clauses. Now we're starting to see the tide turn a little bit, and employers are really starting to pay attention. I think when we talk to our clients, right, when you can actually point to a lawsuit and say, hey, if you're not doing these things that I'm recommending, you could very well get sued. And I think we talked about earlier in the program that we've seen, right, these full page ads taken out by plaintiffs' firms asking for people who are disgruntled with their health plan. We've seen the same thing on social media. Do you work at X large company? Are you happy with your health benefits? A lot of people are not, perhaps not for the reason that the plan is not being monitored in an appropriate way under ERISA, but certainly, rising costs, I think are usually one thing that upset participants, and that seems to have been an unavoidable situation in most health plans. But once you start seeing that solicitation of potential plaintiffs, I think now employers are starting to pay attention and starting to understand, okay, well, if I don't follow the CAA requirements, if I don't go out and get this information so that I don't really have an excuse to not be reviewing it and don't review it properly, I could actually get sued in a very public way and a very expensive way. And so I think now it's finally becoming more concrete for employers, and they're starting to tune in and ask, okay, what do I need to be doing? yes, I'll train my fiduciary committee and help them understand what it means to be a fiduciary. Yes, I'd like to have my consultant or my attorney on these fiduciary committee meetings regularly. Just that kind of hygiene of following out ERISA fiduciary duties that hopefully we would have been doing historically, but perhaps we had not been doing as much without the enforcement piece of it.
Yeah.
And now we're starting to have those conversations finally.
The irony of this is that once they start to look under the hood, I was a hospital president, right? I know there's tremendous variability in quality and cost across the healthcare ecosystem. And as such, I actually think healthcare organizations, hospitals and health systems in particular, actually, Sarah, might be particularly vulnerable in this space because I get it. If I make tires for a living, I might say, well, what do I know about healthcare? We, the healthcare folks, we can't possibly say, oh, we weren't aware there's a tremendous variability in drug costs or tremendous variability in the cost of surgical procedures. And I think they probably need to step up to the plate sooner than others because they're going to be particularly at risk. But, you talk about the educated consumer, so to speak, let's face it, and Alden hit this on the head earlier. There's so much opacity in the healthcare space. Nobody knows what they're paying for, what they're getting for their money. Forget about variability in quality and safety, which, this is the reason MTVA exists. But
I was wondering, you both have the benefit of hindsight with, the original ERISA law and how that may have influenced or changed the pension industry over time. I wonder if you could maybe use a futuristic view of CAA and tell us what you think might happen within the industry because of this. And I'm speaking more specifically to the healthcare industry, right? What kind of downstream impacts could you envision over, the next couple of decades after CAA's had some time and probably some modifications to it and some lawsuits and the like?
Well, I'll take a whack at it. I'm not sure that the historical ERISA informs anything about the future of this. Healthcare, this is a new thing. We have this thing that's eating 20% of our economy. You're talking about multi-trillion dollars annually, and you've got rates of growth that far outstrip the growth of real gross domestic product. So there will be a fundamentally different policy reaction to this than there was to employees systematically losing pension benefits when an auto plant closes in 1973 or so. So I don't think you can draw a lot of inference from history. Going forward, I think the key is the fact that there is so much money involved. Whenever you have this much money involved, there are no simple answers when you're dealing in the trillions of dollars and you're dealing with competing interests on the tectonic scale. So that's where we are right now. And so this is really only Congress ultimately is going to have to sort this out and say this reluctantly, and perhaps to the plaintiffs bar. That's what happened with the 401k world. I mean, there are parallels here. And I gotta say, the Lewandowski complaint was not prepared by amateurs. It really wasn't. I don't know, Sarah, what do you think? Anything to add there? It will be your world, not mine. So there you go.
Yeah, I mean, I think based on what we've seen in the CAA, right, it seems like it's attempting a world in which, and I don't think we're there certainly, but a world in which a participant, a normal person who's seeking healthcare can go online and actually look through what are different plans charging for X procedure, right, in a geographic area, and actually be able to kind of comparison shop a little bit as far as how does my health plan stack up to other health plans. So I think that's what it's starting to get to. We're certainly not there yet because yes, these disclosures are now required under the CAA, but usually they're in machine readable format. Which essentially means if you open these documents, it means nothing to you unless you have certain software. And essentially it's really only helpful for specialty folks like consultants or other people who are able to actually parse the data and try to start benchmarking. And a lot of health plans may not be properly complying or may not be fully complying. So it's just not a complete picture. But I think what it's trying to get us one step closer to is a world in which we can actually compare and say, wow, my health plan is maybe charging me more for this, and this is maybe the going rate for this procedure that I'm looking to get in this geographic area. I think it's starting to get to that, and I think it echoes some of what similar transparency reporting is trying to do on the provider side, on the hospital side as well. But again, I think until we get true compliance with the existing requirements and then probably have the requirements built out even further, we're not going to get into that world. But I think it's an attempt at, if you understand where costs are coming from and how your plan stacks up to other plans, perhaps it's a good way to maybe push for better coverage under your plan. Certainly from the employer perspective, right? You could go back to your vendors and say, why are we charging so much for this drug or this procedure when apparently the average rate in our area is this amount, just to give some ammunition basically to be able to have those conversations, because historically we just haven't even had the data. We have no idea if something is or is not a good deal basically under the health plan at this point.
Yeah, Sarah, I do have just a comment more than a question. The folks on this call and in our networks have been working very hard for years and years and decades to turn the ship around. And we know what the headwinds are like. It's really, really tough. So we tend to cling on these different forces that give us hope for change. And we're hanging a lot of hope on the CAA. And we're hoping that the history does parallel or mirror to some extent the changes that followed the Pension Protection Act. And it took 5 to 7 years for employers to really get it. We're sort of hanging a lot of hope on that because there aren't a lot of bright spots out there, but we really are hoping that with your guidance and your clients that this will make an impact. And so I remain an optimist. John and
No,
Lisa?
yeah, no, and I think, I'm thinking about Alden's comment about the non-parallels actually between ERISA regarding pension and this, and there's a fundamental difference, and I understand now. You guys have helped me because the pension reform, right? The pension was to protect me as an employee for my future, right? When I retire, I'm going to have some money there that's going to help me enjoy my retirement. What's happened over the last 25 years, to Alden's point, is healthcare costs have exceeded the rate of inflation, doubled in most cases, and it's taken money out of the hands of the employees of this country. And I would say mostly the middle class has probably been affected the most. And what I was saying before was, once they start looking under the hood about what they're spending their money on, where they're spending it, what they're paying for, what they're getting for their money, and they start shopping, or employers, not talking about, like they do for everything else that they pay for, guess what? They're going to find we could save a lot of money. And it's not just money for the company, it's money for our employees. And we can lower their deductibles, lower their copays, lower their coinsurance, lower their premiums, and everybody can benefit. Because I think really, and this is what to Alden's point is, at $4.3 trillion, whatever it is today, it's too big a target to be ignored by somebody. But I do think the DOL is probably, and Sarah, I mean, you did some work in the White House, I recall, as I read, during the Affordable Care Act. Do you think the DOL is going to be the one that's going to maybe kind of start taking action, or do you think it's really going to be plaintiff's bar?
Yeah, I think potentially a combination. I think with the Department of Labor, it's a little hard to predict, right? But we're in an election year. A lot of this has shifted with each administration. Like for instance, we just got regulations regarding Affordable Care Act non-discrimination provisions, and we've literally had this is maybe the fourth, I think, version of that, and it's literally changed with every single administration. So I think we're mindful of that reality, right? That the Department of Labor seems very focused on it now, but that could change in January, depending on the outcome of the election. So I think probably a combination of the Department of Labor probably continuing, obviously, to stress this as long as they can in the current administration, at least. But then also, I think the plaintiff's bar has proved really an important potential stick for employers. I think in my, almost 10 years of practice, we've been now telling employers this consistently. We've never said, because you have a health plan, you don't have to comply with ERISA or fiduciary duties. We've always stressed that as attorneys, but now I think we can say that and also point to the cases that are now being filed against employers and say, okay, well, how we've been telling you about this, now we really mean it, because we have the CAA, we have enforcement, at least in the form of the plaintiff's bar, and certainly the Department of Labor has expressed priority for this as well. So I think now that we have some potential penalties, it's maybe becoming more real, but this is sort of a tune we've been singing all along as attorneys, but it seems like now employers are hopefully going to pay attention to a little bit more.
Alden, any final thoughts, final words?
Yeah, so the one observation that I think has some validity here is that if you look at what happened on the 401k side, and these numbers are really gross numbers, just representative of kind of what happened. Before the 401k lawsuits, let's say that the average load that 401k plans were paying their platform providers was about 200 basis points. And then afterwards, after more than a dozen years of litigation, it's closer to 50 basis points. The claim is that something similar to that in a similar arc could happen on the health plan side. You're going now, and I would say that if the retirement plan was 200 basis points, in healthcare, it's more like 300. You look at the commission structure for the small, fully insured plan back 10 years ago, it was probably on the order of 300 basis points. And if we could drive that down to 50 or 100, the savings would be astronomical. But that was done wholly on the backs of the plaintiffs' law firms. Yeah, I agree with Sarah. It will be both, but I suspect that it might be modestly overweight on the plaintiffs' law firms.
Interesting. Well, Alden Bianchi, Sarah Rai, thank you so much for joining MTVA. Thank you, Steve and Lisa, for your questions and dialogue today. This is a huge issue. It's why we're here. And we really believe, as Steve said, we really believe that between the original ERISA law and now the CAA and additions, we're clarifying the role employers have in this space. There's hope to finally get a little more transparency in this crazy healthcare ecosystem, and ultimately to provide actually just better health benefits for employees and saving them money that they could hopefully get in wage increases and other benefits. So thank you guys for joining us today. We greatly appreciate it.
Thank you so much.
Thanks for having us.
Thank you.